Already record. What's going on?
How are you, Brendan?
Good, good. Wow, that's a nice suit.
Thank you. I thought you were going to say the view, but I'll take the compliment for the suit.
Well, of course the view. Of course the view. But that's a nice tie and everything. How's everything going?
Thanks. Yeah, everything's going well. I wanted to retake my photo for the website. I didn't like the first go at it.
I saw you changed. What was it? The WhatsApp or was it the LinkedIn?
Maybe the LinkedIn.
The WhatsApp. The WhatsApp you changed.
Oh, the WhatsApp.
I didn't
Oh,
see
that was
that.
an AI generated
Was it?
based on my LinkedIn photo. I fed my LinkedIn photo to Samsung's AI, and that's what it did. It gave me blue eyes, though. I wasn't complaining, but still.
I see that now. I didn't notice the blue eyes at first. I mean, it came out pretty good.
Yeah, I wish I looked like that, but it is what it is.
Be a good catfishing photo for the. So what's going on? You've made some changes since we last talked.
A lot of changes.
Yeah, let's go into that a little bit. So was Brack Eichler?
Now it's IX Legal on Wall Street, 40 Wall.
And what does IX stand for?
Those are the principal partners' names, Michael Iakovu and Socrates Xanthopoulos. So the I of Iakovu and Xanthopoulos together. But it's going to be a whole new rebrand, a new product, the way we're working. And we have multiple divisions. I'm the chair of the litigation practice here. I got 5, now 6 brilliant litigators that work with me. And we're not afraid to go next door to the real estate group and say, hey, this is a real estate litigation. We need your advice on this. Or this is a non-compete case. And, the transactional group was involved early on. I want someone from that group to help us with this. So it's really nice having this cross-departmental work and also having a team. It's good stuff. And being back in New York. I'm a New Yorker too.
That's right. That's right. Yeah. Yeah, it's great. Well, except for, we were talking last week about the snow and commuting through that. Not great.
Sure.
But better than all the commuting you were doing in your last position, right? Because you were all the way out from Long Island, Riverhead, to all the way up in Westchester and here and there, right?
Yeah, I mean, there was a lot of running around that I had to handle alone. And now we have a team. We can offset each other. We can help each other with whatever litigation load, appearances, and in a way that makes sense too. I'm not going to send everyone to Riverhead if it's not convenient for them, but if you live in Nassau, it's not a lot to ask for you to go over and cover something in Suffolk County.
Right.
That doesn't mean I'm allergic to Suffolk County. I grew up spending summers out in Mattatuck, so I like it out there too. And there's a few really good judges in Suffolk Supreme Court.
Oh, really?
Yeah, excellent judges.
Good. So a lot of changes. Now you're more of your own boss now than you were in the last position, right?
Yeah, absolutely. It's good for me because I have a little more say over what happens. I'm controlling a file, keeping the client in the loop, and keeping a client, keeping involved with a client when they do something with another department.
Right.
So that's good. I mean, I'm a partner now, so it's great.
Yeah, that's the best. That's the best of the best.
Yes.
Cool. So, and one thing we wanted to touch on, we kind of talked a little bit about this. Well, some of the changes as far as there was that law or bill that was passing where, the restricted covenant, that was one, right?
Yeah.
I just thought we could go into some things, for listeners. This is our part 2. A year ago, we did a lot of talking about contracts and negotiations and the differences between contracts if you're signing with a DSO as an oral surgery resident or a dentist in general versus with private practice or maybe academia. And, and I used your services and yourself for contract. So, I mean, I've been absolutely thrilled with it. And
thank you. It means a lot to me.
So yeah, you're my guy that I recommend.
I really appreciate that. Thank you.
Actually, that's a good question. Going forward, it's a great point to set now. Going forward, anyone that asks me who I would recommend, I could still pass them on to you and give them your new contact. And
oh yeah, absolutely. And we're still doing it. I've been getting some queries from dentists, oral surgeons, physicians. They're usually coming out of residency. Oh, they're going from. And I watch your videos. I see it's not a big pay. It's not commensurate with the amount of work you're doing for sure. But going from that situation to actually making that huge increase in salary in the first real big paycheck, it's very easy to put pen to paper and say, hey, I'll take that money. And then you don't know what you're signing away with it. So it's tempting, but it's not, it'd be easier to just get the attorney involved and have an attorney look at your employment agreement and tell you about the red flags, the pitfalls, potential issues, at least have an understanding of what could be going wrong, and I think that's huge.
What are some of the recent red flags and pitfalls that you've seen?
Very overbroad non-compete language, geographically going well beyond the scope. Something, I have a case now I'm dealing with here where it said, the Eastern United States. And first thing the judge said was like, that's overbroad, which is good for us. But now the client still has to pay to litigate through this issue. And, we weren't involved with the signing of that agreement, but something like that, just having to fight to put yourself in a position to win is very costly. Whereas having counsel early on tell you, hey, don't sign this, it says the entire Eastern United States. Let's work on something more reasonable, would save you that time on the back end. So when someone wants to know what it costs, I would say less than 1% of the litigation from the employer, especially a tough, DSO or, private equity owned business. They want to make an example potentially of an employee, of a young oral surgeon starting his or her career, and say, okay, everyone else watch what we do with this person.
Just to rewind a little bit. So what you're saying is, in this particular case, not to get into the nitty-gritty details, but just from a broad scope, this is someone who came to your help, came asking you for help, but had signed with either not having an attorney revise or look at their contract, or someone who didn't really look at it. Maybe they sent it like their aunt, hey, can you just look at this real quick? And they're like in some other type of law. Is that like the situation that happened?
Yeah, for that case, it's exactly what happened. There's a lot of zeros on this number. Let me just sign this. Why should I spend money on it? I'll just sign it right now. And yeah, okay. Well, the first thing we said was that's overbroad, but we still have to litigate it. It doesn't just fall apart. You still have to send someone to court. You still have to answer papers. You still have to file an answer to a complaint. And it's tedious and it's time consuming and it's very costly. And it could have been avoided.
Right. You remember how much we go into my contract? We had talked about how they in my contract it had said dentistry, but then we revised it. You say, wait, it says dentistry right here. We're gonna have to revise this to oral maxillofacial surgery. I thought that was such a great point. It's something that when I read the contract, I just breezed right over it. I was like, all right, whatever. And then you guys were like, wait, and then you guys pulled out some case in the literature back to like 2016. They're like, this is what happened with that person, which was also Long Island. I thought that was incredible. And now, are most of the cases that you're seeing that end up being brought to you with problems, are they all predominantly, they didn't have it signed, they didn't look at it, they just signed it? Do you ever get these cases where they were signed by an attorney and looked over and reviewed and modified?
Yes.
Predominantly not, right?
Yeah, no, but there are a few. And again, it's probably there's someone outside the comfort zone, or what the client will say is, hey, you know what? I wasn't told about this issue.
Yeah.
Maybe there were some revisions from the attorney, a little back and forth. Maybe the attorney fought on a non-compete issue, but ultimately didn't succeed on it and doesn't go back and have that conversation with the client and say, hey, Brennan, guess what? They're pushing back here. We have to consider that 15 miles from these 3 locations would pretty much do us out of Nassau County,
Right.
and that conversation, the client says, was never something that she had with that attorney.
Yeah. What's the worst? I just thought of this real quick. What's the worst restricted covenant? Like what's the worst mileage you've ever seen?
I saw nationwide. That's absurd. But for real medical professionals, the worst I've seen that's been upheld is 50 miles. 50 miles, and it's been upheld. And it's a real, and the courts will not give you guys an inch because they consider you very sophisticated. They treat you like you're attorneys when you get these employment agreements. And so you guys have advanced education, right? Higher knowledge, technical skill, ability, all that. They're not going to treat it like the nail stylist, the hair salon stylist that's saying this is unfair because what was I even taught, here where they're telling me I can't compete with this and go uptown to another stylist or salon and be able to provide services there. So you guys do not get the benefit of the doubt in the courts, unfortunately, which is more reason to offset it by taking preventative measures at the time you get an offer.
Have you seen that when you've been litigating in court? Have you seen judges say like, oh, well, this patient's, this, what do you call it? Client? Your client is a doctor. Your client is a dentist. Your client is that's come up, and they're like,
and it's in the decisions. You'll see it in the appellate division decisions, and it's just like, well, you should have known better. You're a medical professional. You make the big bucks, right? Like it should be, and that's if you look at the governor's veto of the proposed restrictive covenant bill that would have prevented it from happening. The governor's position was she's trying to protect low-income earners, and that's not something that applies to medical professionals outside of residency, right? It's like once you're there, why should I feel bad for you kind of thing? And that's the courts echo that, unfortunately.
Yeah. So it's kind of like comparing apples to oranges as far as like professionals being, say, the apples and stuff, and the orange being like the lower income people, like you were mentioning the hairstylist, the hair salon, person, whatever. So, okay, it applies to them, but doesn't apply to them, even though the law is the same. And then what happened to that law or bill? Because I didn't keep up with where it ever ended up settling.
It was passed by both houses in the state, and the governor issued a veto. And she explained that the veto was to protect low-income earners. This is not the way it's written right now. It doesn't discriminate, and it would protect the highest earning people and the C-suite executives at these big companies, and wouldn't really protect, the lower class, the working class as we have it. But in the medical field, I don't know that I would necessarily agree, because if my doctor has to leave, my dentist has to get up and physically leave the county, the state, or what have you. If I don't have the means, I'm not going to follow that person. So patient access was kind of just thrown into that veto as well. And I don't know if that was done purposefully or if it was overlooked, but it's something to consider, that people they build relationships and rapport with their dentists, with their oral surgeons, with their general physicians, and they want to keep these people for however long, for their lives. It's like a lifelong relationship.
Absolutely.
You spend a lot of time in fostering this relationship. You have a good bedside manner. You show a high level of care. Someone's going to appreciate that. They'll know it right away. Yep. If they try and replace you with a machine, no one's going to want that, because patients want to be treated a certain way, and if they can't follow their medical professionals, then they're stuck having to make a tough choice.
Yeah. And that's such a great point too. I can't tell you how many patients come in and say, hey, I get a lot of anxiety at the dentist. I'm just letting you know now. And it takes me a lot to trust that person to work in my mouth, because it's such a sensitive area. And I'm like, I get it. I understand. And that goes for all patients, whether it's the mouth, whether it's the private parts. Like, it's a very serious thing to change your healthcare provider. And yeah, that just doesn't work. Now, for listeners, including myself, this might be embarrassing, but when you say it was the governor, no, not the, I'm sorry, who vetoed this bill?
Yeah, it was the governor.
It was the governor. And what does that mean as far as vetoing? Like, it was passed, right? But then it was vetoed, and now can it slip through the cracks? Is it gonna go on at all, or is like this is completely down and out, done?
It's done. It's done. So you have two houses in the state legislature. You have the state assembly and the state senate. Actually, one of the partners at this firm is a member of the state assembly, and he's in the injury practice. And so it will pass one house and travel to the other, not unlike the way it works in Congress. And once it passes, it goes to the governor for signature, and she has the right to sign it. She also has the right to veto it. And if she vetoes it, it has to be passed then by 2/3. It has to get over that extra hurdle. And there wasn't enough support for it, even though it was pretty bipartisan. There's not enough support for it. I haven't heard anything since. And there's also been the recent SEC ruling that's been on hold it proposed doing that nationwide. And it was challenged in federal court in Texas, and has been on hold ever since.
Vetoing it nationwide.
Yeah, and it was one of the issues, and the challenge was whether or not the SEC has the ability to do that. Mm-hmm. And it was a proposal saying, well, we don't find this fair generally, but this is how it should be done, and people shouldn't be restricted in this manner. And it was challenged by a lobbying company out of Washington. They got on a jet to Texas the next day. And it was also challenged by an accounting firm in Texas. But the accounting firm was, I guess, second to file. So the judge stayed that case pending determination here. It's been stayed. It doesn't look like it's going to get traction going forward. So it'll be an issue for states, and it'll go on a state-by-state basis, most likely in the future.
So then you live in New York, you're screwed.
For now, yeah.
Oh, sounds like everything else, the taxes, the real estate, oh, man. Well, all right. Well, that's something to digest, I guess. Some of the other things that we were looking at on the contracts. Let's see, what else? What else was it? Well, there's disability insurance. I'm looking at that right now. There's also malpractice, right? Yeah. Is that covered by the practice or not? And then what's it called? The tail? Is that right?
So you were looking at either claims-based or occurrence-based, and there's a huge difference based on whether the coverage is for when the claim is made or when the actual conduct is alleged to have occurred. And so if you leave jobs or you open your own practice or whatever, and it's based on when the claim is made, you can't go back to the insurer or your employer's insurance for that time and say, hey, you got to cover me. So it's something that has to be negotiated with the agreement, and it has to be taken into consideration. If it's not something the employer is willing to give an inch on, we're going to have that conversation, and we're going to explain that, listen, it could happen this way.
Most tails was it 1 year or 2 years that we're talking about?
I've seen both. And now it looks like it's going closer to 1 year to minimize coverage, but it used to be 2 years pretty standard.
Okay, got it. Yeah, that's something that I didn't understand prior to our discussion on that with the contracts, because obviously malpractice, especially in surgery, is very, very big. It's very important, and yeah, especially in surgery, because then exactly what you said, when it's filed, that could really affect the surgeon in the practice. What was another thing we were pointing out?
There was also scope and duties, and that, like the dentist generally versus oral surgeon, because you could practice just oral surgery. And if you're just practicing oral surgery and you're being restricted now for dentistry,
yeah,
I mean, your non-compete wouldn't be violated otherwise if you just went and practiced general dentistry. And then the locations, right? If it says the employee shall work wherever the employer says, and it's like, well, there's one office now, but they opened 5 offices and they're across in Long Island, and now you have to travel across Nassau and Suffolk County, and you're bound to it because that's what you originally signed, versus saying the employee shall work primarily at this location. And if there is a change, if they open another location, that's a conversation. Hey, Brendan, listen, we have a second location here. Would you like to go there? No. Okay, how can we entice you to go there? We'll give you more money, we'll pay for your car, whatever and then that's a benefit to you. Whereas if you had signed it with a little more vague language, they could hold that against you, and you don't get anything for taking that extra trip.
Right. That's a good point. So paying for the car, paying for the mileage, paying for the time spent traveling a different distance. One of the things I love that you guys put into the contract was, you and Andrew proposed this, for any office that you're working at less than 1/3 of the time, that should be exempt from restrictive covenant. Did I say that correctly?
Yeah.
That is such a good point. And this is really important for dentists, surgeons working at DSOs, because many times you're working at Aspen Dental, you're working at so-and-so DSO, and you're working at only 4 days a week. They love to say, oh, I'm only 4 days a week. But they're commuting 2 hours one way to Minnesota, another hour this way to God knows where, Squirrel's Crotch. And in the middle of it, I had a brother in high school that used to call every place far away Squirrel's Crotch. I thought that was hilarious. It's like, it's benign, but it's like creative. Anyway, he was a brother, like one of the ones. But anyway, but those 4 hours, getting it down, if you worked in one office less than 1/3 of the time, getting exempt from that restricted covenant, that could save someone's future career if they're looking to move and they happen to be in that area. That was such an important insight. And how did you guys come up with that?
Well, it's a very fair argument. If you look at the arguments in favor of restrictive covenants, generally, it's like, well, there's all this time being spent here, and you're learning our customer base, our patient base, and you're benefiting from being here. And because you're here so frequently, you're a fixture, right? You're going to go across the street and you're going to steal our patients. Whereas we're saying, no, you're not a fixture here. If you're not spending X amount of time here, total by percentage, by every week or every month, whatever the basis is, then you're really not here enough so that you can say there's unfair competition. So there is a logical underlying basis for it. Not every employer understands that, and some people just don't want to negotiate either. We were fortunate enough that this employer saw that for what it was and was able to appreciate. I can't give the details. It's the client that has the right to give the details. So that's my obligation. If anything you want to share, I could speak to, but I'm not allowed to those are my ethical duties.
Oh, absolutely. Yeah. I mean, I think we didn't touch on employer or this and that. I think we're just touching on some really fair points, really important points that could go for any oral surgeon dentist, right? And I'm bringing this up because it's a testament to you. These are the legal minds. This is a different, like the perspective of an attorney that we absolutely do not have any understanding of as a dentist, as a doctor, as a surgeon, as you know what I mean? But then when you bring it up and we go through these points, it's like, oh yeah, that really makes sense. Or, oh yeah, I brushed right over that. I didn't even think twice. So that's why, I really like to kind of dissect these conversations and just remembering back to some of the things we talked about. I mean, I don't see this being, an issue as far as bringing it up on, on the chat here. But what's another thing you've seen that I think is that you would say is a really common theme of contracts, and that dentists, doctors, surgeons just brush right over you? What's another thing that is these red flags are so important because we just read right over them like, oh yeah, that makes sense, and it's bad. But then you guys pick it out like, this is something that says something about your employer that I don't like. You know what I mean? Or about your employer's attorney maybe that I don't like.
Yeah. The first thing that comes to mind are these false promises of partnership.
Mm.
And so, the client will say, hey, I was promised in 3 years I'd be offered partnership. And then the agreement comes through and it's either completely not there or there's an agreement to agree in the future. Like at some later date, the parties would discuss, the concept or the prospect of an ownership interest for the employee. And that's nothing. That's totally illusory. It's not enforceable.
Right.
And so, just trying to find that in the agreement and seeing that it doesn't come through in a meaningful manner, especially to compare to what this person was told. The client was told, hey, in 3 years, you're going to have a 10% interest, a buy-in or not, or whatever. And it's completely not reflected in the employment agreement. And we're telling them, okay, we've settled these other issues, but this is a huge issue. And unless this is settled now, treat it as if it doesn't exist.
Yeah.
And just figure out based on that whether or not you want to continue.
Have you been able to kind of finagle anything into contracts as far as partnership goes?
Sorry, say that again.
Oh yeah, I was saying, have you been able to like finagle anything into contracts as far as partnership goes when it was something like written down on a napkin maybe previously, and then you brought it up with your client and they brought it up with the employer, and then we were able to get it in there when it seemed like the owner was trying to keep it out purposefully?
We've had issues where emails have gone back and forth because the attorney is going to take a hard line. The employer's attorney, they're usually going to be like, no, unless my client tells me this, I'm not putting it in the contract. Yeah. This is what we have. This is what we're going by. So we'll see an email exchange, and there's a good relationship between the client and the future employer. And typically it's smaller practice environment. And the idea is, hey, I'm getting up there in age. I want to see how you handle the first 3, 5, 7 years, but my goal is to have you succeed me in this business. And so with those emails, we then push back and say, hey, this isn't me saying this. This is your client telling my client this.
Right.
Or text messages or WhatsApp or what have you. And that's led to movement and actually papering that future ownership deal in a way that's meaningful and lawful and, can be enforced.
Yeah. That's pretty big. Because, and then from the employer's standpoint, I mean, I can completely understand that, where you want to keep it kind of vague because it's still a tryout for that employee. What if in a year or two they're just exhibiting gross misunderstanding? They're maybe they're incompetent, or maybe they're really good surgically, but they just can't talk to patients. They can put them at ease. People are having bad experiences in the office. Let's flip the script, because you do contracts for employers too, right?
Yes.
How would you kind of phrase that? That would be an interesting thing. Or how do you just keep it out of the contract entirely, or do you phrase it where
it would be a few more conversations with the employer client as far as whether or not that's something that's being considered? If there are metrics that we could use that are objective that we can build in and say, well, you have to have X in total net receivables or whatever over an average period of time, or something where we could actually look back at records and say, okay, you've met these metrics. Now you can get whatever percentage it is. And it is something that we're hesitant to, on the other side, push, because someone might do a deal and find that there's no bedside manner for the surgeon, or, the person is good at what she does or he does, but speaks to patients and coworkers very poorly in a demeaning manner and doesn't have a good rapport with people. Maybe everything is great, but there's no business acumen. And so you don't really see this person being able to support or sustain a practice with maybe one other surgeon who's even more junior in the future.
Right. Because then, the demeanor, the communication with staff or patients, I see what you mean. You want to put deliverable metrics for the client, or, the employee versus the employer. When you put those metrics, say you need to meet certain goals, I guess financially, Do you put them too high?
No, it's obviously it's not like a carrot on a stick. I mean, it has to be, because again, we don't want to get into the position. The other side would say it with their attorney. Hopefully, they have an attorney, but they would say, "Hey, this isn't achievable. You're promising a future. You're going to agree at some later date, and that's not an enforceable contract." So the other side will cue on it, and or maybe they'll have that conversation with their client and say, "Well, that's not a realistic goal because of." One, two, three. One of the bigger things on the employer side now is including very, very strict language on harassment, discrimination, retaliation, because you might have that employee who's a phenomenal surgeon, but maybe the demeanor, the attitude towards patients or coworkers is such that it would rise to the level of harassment or discrimination. You want to have a for-cause termination clause based on that in a way that's fair and impartial. That you don't want someone like that taking over your practice.
Right. That's an excellent point. Huh. Has there been, what's the craziest thing or case that if you could talk about it? What's been a really crazy thing that you've seen?
We do some outside investigations on behalf of clients, employers, and I mean, you want to talk about discrimination or harassment or something like that, or hostile work environment claim, and coming to a conclusion that yes, this is as bad, if not worse, than anything we've read about in the papers or the textbooks or whatever, and just finding a level of pervasion of whatever bad behavior it is, where it's going unchecked, or anything, or improper fraternization between a superior and a lower level employee, that can give rise to a quid pro quo harassment claim. And an employee can say, hey, you made it seem like it was necessary for me to maintain a relationship with you in order to be an employee here, or to continue employment, or maybe to advance in the company. And so typically management wants to get ahead of that. And as far as that goes, I mean, I've seen some very salacious things, but yeah, I mean, if the operation isn't managed properly, it could turn into a suit. It really can. Patient fraternization, I mean, you name it.
Have you seen a lot of that?
Not a lot of it, but when you see it, when it rains, it pours. It's like it's more than just one issue.
Yeah.
But it's always good for the clients to get ahead of it, for management to take a step in and actively try and determine what's happening, nip it in the bud, investigate it fully, and take appropriate action. But yeah, when these things go unchecked for too long, it can be very bad.
And that does make sense. Yeah. I'm just thinking to go back to the topic of contracts. You were saying contracts with private offices, owners, tend to be a bit more vague, and then that could be potentially harmful to the employee. But what about as far as just overall the contracts that have been a little bit more harsh? Or I know you were saying when we met at the program, this is going back probably 2 years ago now, actually. Thanks to Dr. Kajanis. Shout out to him.
Yeah, he's great.
Yeah. We were talking about how DSOs, with the having a lot more money behind them, they have all these offices sometimes, that their contract might be a bit more outlined, but they're much more strict. Would you agree with that? Is that yeah? Could we go into that a little bit further? Sure. And then I also wanted to find like the difference in the restrictive covenant out in maybe the suburbs versus in the city where it's blocked. And we don't even have to get to that.
Yeah, absolutely. No, I mean, these are both good points. What we've been finding is that some of these smaller practices, they don't, just like we're telling, the medical professionals finishing a residency, hey, you need an attorney. We have to tell these smaller practices that too. And you'd think, at what point is it still a small practice? But you'd be surprised as far as revenue. Some of these practices have grown, they've scaled, and they haven't changed the way that they work. And they're still kind of operating like a small business, a mom and pop shop, even though they're bringing in tremendous amounts of revenue. Their patient base has exploded. They have so many employees, and they're not considering things like, well, let's have an employment agreement instead of like, let me just download something from the internet. Oh, it's not for New York. It doesn't matter. I'll just scratch that out and I'll fill in the blanks, whatever happens. It's hard to convince those people with those mindsets. Like, this is, yeah, okay, fine. You have to pay for services, but again, it's going to be a lot less expensive, and less than 1% of what it would cost for you to litigate this issue. And that can run from even the harassment, discrimination, and retaliation gamut, or wage and hour issues, and it could run into non-competes. I mean, there's so much exposure across a number of fields for these employers. So typically the private equity backed ownership is conscious of that, and they know what their exposure would be, and they want to maximize profits. And so sometimes to maximize profits, you spend that money early on, and you do have a much tighter employment agreement because you know what to expect.
Right. Have you seen anyone getting let go from say DSOs or any practice really, where it comes down to some litigation to try and haggle with the restrictive covenant or the tail or other major things that are on that contract?
Yeah, but we try to advise the client to sort of work out a deal based on how much hunger they have for litigation. Obviously anticipating the costs. It's a conversation that, I want to have early on. My team would want to have early on to explain this is what it would cost to go through this phase, to go through discovery, and then, of course there's a range there and you don't know how hungry the other side is for litigation. But if we can walk away and have sort of an agreement that may not be in that employment agreement and say, okay, well, I'm not going to practice in Eastern Suffolk, and we'll draw a line through Riverhead or whatever town you want, and I won't practice east of there. And so even though that's not what I agreed to originally, we avoid litigation and we agree that this new agreement and we'll reduce the number of months for the non-compete. We'll go from 18 to 12 or whatever it is. And there's a back and forth to that, but it takes a lot of money compared to litigation, and who knows what the outcome will be. And even if you win in court, you might lose on appeal.
Yeah. No, that's interesting. So if they want this, then they could give a little bit of that, and kind of balance it out, a little bit of compromise there. That's yeah. No, that's interesting. We had something where it was a little back and forth like that. Let's so the blocks. Isn't there something in Manhattan where they'll say above like this block if is that right? Does that go for Brooklyn too, or?
It depends. So the argument is Manhattan, if you say miles, it might be too overbroad because you have X number of businesses within those miles. And we would look on it from both sides, from the employer side, the employee side would say, well, there's 15 oral surgery practices within this 5-mile restriction, or there's 50. And so when you tell us 5 miles in the suburbs, or you tell us 5 city blocks, it covers the same number of practices. And you do have these little bubbles, pockets within the city. And just because Manhattan is large as an island doesn't mean that someone's going to go and see an oral surgeon from one end to the other, or even from the west, from Midtown West going over to Midtown East. So dividing up the city into blocks has been a sort of compromise for both sides to figure out what's fair and what's not.
Related to sometimes in the hospital, you see these representatives of certain surgical parts or pieces or plates, and they have their kind of territory based on city blocks too, which all that was pretty new to me because I grew up on Long Island. So anyway, let's switch. This is just to wrap up a little bit here. I never got to ask this. What's your favorite kind of law to practice?
That's a good question. Favorite for me is being able to do something preventative, whether that's employment or whether it's in the context of a potential shareholder dispute. I've represented also some of these smaller practices where there's a disagreement between the partners. And they're headed towards divorce and sort of working that out. But being able to do that preventative care, and I think you might agree as an oral surgeon, the preventative care would prevent you from having to get into this involved, intensive procedure later on.
Yeah.
Saving the person that time and effort, for me, is usually the most beneficial, rewarding, and otherwise just because you are saving it. You're saving time, you're saving money, you're saving stress. There's a lot involved there. And I think in any context, being able to do that and get in early and help a client across the board with whatever it is, the issues that this small practice, they're looking to bring in a new oral surgeon, but they also have issues with, potential liability, licensing issues. They haven't worked out trademarks. There's so much involved in a business. Framing the question as, can you prepare an employment agreement for this new employee, might be short-sighted because this employee is going to, buy in a few years, but you never trademarked your mark, right? You don't have a trademark. And now a competitor comes 5 years later and this employee's become your partner, and you both now have to deal with this issue that could have been resolved if we had these extra conversations. It's usually why I want to get some of my partners here from the different departments involved in an early conversation, maybe even bring them into that intake meeting So we can sit down and say, how can we actually deal with all the moving parts? Just because you think one thing is important, maybe you're overlooking something else.
Yeah, and that requires a lot of foresight in this. That's a really good point. And I did notice that about working with you, was that like 9 months ago now? Yeah, that's so important because then you're saying, well, if we continue with this, that, or like the rather than changing dentistry to oral surgery, the point was that, well, in this case, back in this time, they couldn't practice any kind of dentistry for a year or two. That's really, it was like 2 or 3 years. That's really crucial. Do you have any examples or cases that you had worked on in the past that really connect? Because you said you find a lot of like the passion in this type of work, the preventative work. Is there any case or something that comes to mind that was like this is what you think of, like this is what you go to on that, on that.
Yeah, I mean, we had last month here at IX Legal, we had a client come in. The concern was, hey, we have a lawsuit, it's a wage and hour case. And as we're looking into the details, it's more than litigation. There's actually a trademark infringement component. And there are issues as far as actual ownership, right? Or versus corporate entities responsible. Like, oh, you have the lease in your name individually. Why didn't you have an entity do that? And sort of looking at everything in perspective and being able to bring a multifaceted approach to the client. And I think the client appreciated that right away, and realized that these were all big issues. It wasn't just the lawsuit. It was the exposure generally in these different areas that caused the client to step up and say, okay, I actually want to sleep well at night and I want to handle everything. I want to tackle all of these issues and be able to know going forward we're in a better place. So maybe let's look to revising and upgrading our handbooks for our employees. Let's look to changing the structure to file a complaint for harassment, discrimination, retaliation. Let's do all these things and implement them so that I can give to the next generation, or my partners or whoever it is can also benefit from this.
Right. Huh. And it went well?
It went very well, and we're excited to be working with this client. And it's good because everyone's involved. I like that everyone's involved. I like that I can go 2 offices down to a transactional attorney and sit with this person and say, hey, look at this employment agreement. What does that tell you? Because I'm litigating this issue. Well, how would you read that and why? And give me some feedback. Or you did this agreement. Now we're in litigation. What was this about? Do you have communications with the other side? We're like sharing ideas. We're sharing strategy, and the client benefits.
That type of collaboration is awesome. And then you could learn something from it. They can learn something from it. And then going forward, you have a relationship with that person to get an idea what their perspective is on it. You see that in surgery too. Yeah, that's a really great point.
Patients benefit in surgery when that happens. So sharing ideas like that it's only going to benefit your patients, and that's what the goal is, right? Like that's what needs to be done.
Yeah. Awesome. Konstantine, thanks so much for coming on. Hey, I haven't forgotten about the idea. When you find like someone who might be good for this, I would love to do like once every 3 months, we bring up maybe 3 to 5 cases within dentistry that will apply to dentists, residents, anyone that I think going through that and kind of just getting your perspective of this. It's literally what you just said, going over to an office next door and asking that transactional attorney, well, as a dentist, surgeon, doc, whatever, and then listeners too, if we could kind of go through that this might click to certain experiences, or at least get them an understanding of how much more insight you have on these issues and little points, bullet points on a term sheet. We didn't get into term sheet today for the next one, but that's so important. No, I think a seasonal thing would go so far. We do it in oral pathology trivia. I would love to do that in law because I'd like to learn these things too. It's an idea. We'll do it in the future when we can when we have more resources. That would be fun if you'd be interested in that.
No, I'm interested. I'm very interested. And there are other attorneys here that have ideas and have knowledge beyond my scope, and I'm happy to have them contribute too.
Yeah, that would be cool. Between employment and actually injury too, personal injury and malpractice. That would be go through like 5 cases every 3 to 6 months. That could be a really important and beneficial, very valuable podcast.
Yeah, absolutely.
I would love that. So yeah, we'll touch on that. But I know you got to get out of here. The sun's almost down. You got to drive home, right?
I'm gonna enjoy the sunset.
All right, Konstantine. Thanks so much for coming on again.
Absolute pleasure, and thank you for having me.
Thank you. Thanks. It was always great working with you, man.
Thank you. Yeah. Our feeling is mutual.
All right. We'll talk soon.
You got it. Thanks again.
Good night.
Good night.